Um, Hello, hello, everybody. Let's see what I can do here. It's not gonna work. Hello, 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 everybody. I'm trying to make this work so you guys can see it. But I'm. Oh, wait, how about if I do this? Let's go. 25. Alright, that might work a little bit better. There we go. Hello, 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 hello. We are doing Karen Reed today. Hello, 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 hello. Oops. Okay, I think that I have figured it out. I hope that I figured it out. Who knows? Ah, what am I doing? Okay, we're good. Minimize this, minimize this. Okay. All right. Let's make this a little, oh, nope, that's not. It's definitely easier on my like laptop than it is on my desktop, which I like, but we'll see how it goes today. But yes, we're gonna do some Karen Reed. We're gonna go not for long, maybe like an hour, and then we'll. I don't know how well you can see that, but I hope you can see it well. Hello, everybody. Hello, hello, hello. Happy Friday, everyone. Yay! It's Friday, it's Friday, it's Friday, it's Friday, it's Friday, it's Friday. Sorry. I'm tired as shit. Tired as shit. Tired as shit. Hello, hello, hello. I wanted to go over this with you guys today. Try to get this one knocked out. Hello. She's in court on January 20th. I checked with the court today. No changes, no updates, no nothing. So your guess is as good as mine what's going to happen on January 20th. Maybe she'll have a plea, maybe she won't. I should be at some plot point party on Friday. Back in the day, maybe. Not anymore. I mean, he did press charges, right? That's why she's in court. where it sets up into a cliffhanger for the next season. Oh, those days are behind me. Those days are behind me. All right. Who's ready for some Karen Reed? This is actually like a relatively funny document. Because Proctor like says nothing but also says like a lot, and I'm very confused by some of his answers. So essentially what this document is a response, well, they call it an answer to the questions and the interrogatories basically asked by Karen Reed's team. So technically not interrogatories, but there's a bunch of statements made in Karen Reed's complaint, and this is his answer to her complaint. So a lot of these you're not going to understand, but I'll make it make sense for you. All right. This is the civil case. Okay. This is the civil case of Karen Reed against Proctor, Buchanan, Tully, Albert, McCabe, and Higgins. So this is not the O'Keefe's suit against Karen. This is Karen's suit against them. All right. Well, let's start at the top. Okay. Proctor's first defense to all of this is that Karen's complaint fails to state a claim against defendant Michael Proctor, upon which relief can be granted and therefore must be dismissed, which is bullshit because we know that she can get relief for all of her claims. And then his second defense is Proctor hereby responds to the allegations contained in the plaintiff's complaint, the amended complaint, paragraph by paragraph as follows. So some of these are going to just say like denies, no response necessary. So we'll go quickly through those because I don't have Karen's matching up with us. So I'm probably going to do a YouTube video this weekend where they match so you can see what they say. But for now, we're just going to plow through them. The allegations contained in this paragraph are introductory in nature and contain legal conclusions. No response necessary. To the extent a response is required, they are denied. The allegations contained in this paragraph are introductory. Same thing. Number 3, it is admitted that Proctor grew up and resides in Canton, Massachusetts, that Brian Albert was a Boston police officer, and that Brian Higgins was an agent with the ETF. As to the remaining allegations, they are denied. Interesting that he's using past tense, but for Brian, is Brian Higgins not with the ATF anymore? Number 4, to the extent that a response is required, it is admitted that Mr. O'Keefe had bruises and lacerations on his face and a deep gash to the back of his head and scratches on his right arm and forearm. Denied that there was an unwritten rule of protecting their own. As to the remaining allegations, Proctor is without knowledge or information sufficient to form a belief as their truth. This is funny to me. Denied that there is an unwritten rule of protecting their own, because we all know that that exists. And to deny that exists seems a little asinine, right? We all know that cops protect cops. That's not news to literally anybody. It's not news to literally anybody. So we're jumping off the gate here with some bullshit from Proctor and his lawyer. It would have just been easier to be like, yeah, no, cops sometimes protect each other. Like, I would get a little goodwill from people, but like, all right, we're just gonna jump right over that. 5. It is admitted that Proctor sent texts which speak for themselves. He sent texts that speak for themselves. Yes, we know you did, sir. We know you did. They were terrible and awful. Denied that Proctor shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. As to the remaining allegations, Proctor is without knowledge or information to form a belief as to their truth. Okay, so denied that Proctor shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. Yeah, because you didn't do any fundamental investigatory procedures. How can you sidestep them if you didn't do any of them? There's a thought. It would be nice if you actually did any at all. Okay. Number 6. To the extent a response is required, is it admitted that Proctor did not search the house for blood evidence, fingerprints, or DNA? I'm glad we're finally admitting that you suck. Admitted that O'Keefe was found without a coat, hat, and one shoe. As to the remaining allegations, they are denied. I can skip 7. To the extent a response is required, admitted that only that Proctor provided information to his sister. As to the remaining allegations, they are denied. All right, so he's at least admitting a little bit of culpability here. 10, to the extent a response is required, it is admitted that Proctor sent text messages to his high school friends, sister, and state police colleague, which speak for themselves. As to the remaining allegations, they are denied. Oh, they speak for themselves. Yes, I will post this on YouTube. I'll post this live on YouTube. You're not super late. We literally just started because I got on late. Yes, the O'Keefe docs, Viv. It's just Proctor's response to Karen's complaint. But it's just funny because when you're a lawyer, you have to like artfully come up with ways to say, I know my client's an ass, but I have to somehow say that without saying that. So the way that he has chosen to do this is to say it is admitted that Proctor sent text messages to his high school friends, sister, and state police colleagues, which speak for themselves. So instead of being like, we totally admit that they were wildly inappropriate, he just says they speak for themselves. That's his way of saying they suck and they're inappropriate and we're not professional. They just speak for themselves. Love that for him. I wonderfully worded and excellently crafted, but it's just funny because like we all know what they're trying to do, right? Number 11, to the extent that a response is required, the allegations in this paragraph refer to other defendants, therefore no response is necessary. Number 12, the allegations also refer to other defendants. Number 13, the allegations contain legal conclusions, therefore no response. Responding further, Proctor admits he was terminated by the Massachusetts State Police. Is that all? Is that all we want to say? Mikey P? Mikey P? Is that all we're gonna say? You were not just terminated. You were decertified, sir. Meaning you cannot be a law enforcement officer anywhere in the state of Massachusetts. You were outright decertified. Thank you for the follow, whoever followed. Welcome to the team. So yes, not only you were terminated, but you were decertified, but you left that out. So wonderful. Also in these like answers, what I'm laughing at is you put the least amount of information possible. Like I know that, but like you're meant to answer them with the least amount of possible with the least amount of culpability for your client, right? And admitting the least amount of information. So it's funny to read these because I know that this attorney was just sitting there being like, son of a bitch, how am I going to word this to make him not look like an ass? Number 14, to the extent that a response is required, the allegations in this paragraph refer to other defendants. And then we move on to the parties. We see if there's any. Admitted that Proctor is a former Massachusetts state trooper and that he resides in Canton. Then he does not know anything to help with those questions. Jurisdiction and venue. Not really super important about jurisdiction and venue. Miss O'Keefe's death. Admitted that on January 28th, 2022, Mr. O'Keefe and Miss Reed went to see if McCarthy's in Canton and then went to the Waterfall bar in Canton. Also admitted that Mr. O'Keefe was drinking. Denied that Miss Reed had several drinks. She had at least 9. As to the remaining allegations, Proctor is without knowledge or information sufficient to form a belief as to their truth and calls upon plaintiff to prove them. I know we all watched trial 1 and we watched trial 2. Was it ever proved how many drinks specifically she had? Was like 9 the number? I don't think 9 was the number. I don't think 9 was the number. Thank you guys for the heart me's. I appreciate it. I think they settled around like 5 or 6. Because I remember her saying like they were strong, right? Like they were like, or they were weak. I don't remember if she said they were strong. I don't remember. It was a while ago. But I don't remember the number 9 coming up. And to say she had at least 9 is, she said they were weak, right? At least 9 is like, that's where, she was drinking vodka, right? Right, she was adding an extra shot. Oh, thank you. That's a fun one. The forest elf, I like that. Thank you. Like, how would she? Yeah, I remember, and she was like adding an extra shot, so it was like 2 shots in one drink. So she didn't have at least, unless he means like adding the shot made it more drinks. But like 9 is a high number, and to say she had at least 9 is reckless. Is reckless drafting because that's a hard one. That was not proven at trial or in any testimony. Did she? So she's saying he had at least 9 shots. I guess you could infer that from that she had at least 9 shots. I think if you wanted to like go with she had at least 9 shots with out of the total night combined in her drinks, maybe that's more realistic. I don't know. That's a lot. That's a lot. It's been almost 8 years since I've had a drink, so 1 shot would knock me on my ass, but like 9 is a freaking. Thank you, Jamie. Right. I agree with you. I agree with you. If she was, and it seemed as if she was a regular drinker, right? Like it seemed like she went out a lot. So, I mean, like, what else do you do in the winter in Canton, Massachusetts? To be quite frank, I don't know what else you do in the snow. But that's. All right. Admitted that Jen McCabe told O'Keefe that he should come to the house. As to the remaining, Proctor's without knowledge. Admitted that Brian Albert and Mr. O'Keefe were Boston police officers and that Mr. Higgins was an ATF officer. Admitted that Kevin Albert and Proctor had a professional relationship. Da-da-da. Miss Reed searches for Mr. O'Keefe. Heard it without knowledge, without knowledge, without knowledge. Investigation begins. Admitted that the Canton PD was the admitted that the Canton Police Department were the first should be was the first law enforcement officer or the Canton Police Department were the maybe not were the first law enforcement officers on the scene. Proctor leads MSP investigation despite conflicts. Admitted that Proctor was assigned as the case officer. Doesn't say lead investigator though. Remember that was like a point of contention in the trial. In the second trial, AJ kept trying to get them to say lead investigator, and they were like, "No, he wasn't the lead investigator. We're not going to say he's the lead investigator." So now we're going with case officer instead of lead investigator, despite him being called the lead investigator in the entire first freaking trial. And that Buchanan and Tully were supervisors at the Norfolk County State Police Detective Unit. Proctor denies that he engaged in misconduct. I'm gonna say that again because I couldn't get the words out because they made me want to vomit. Proctor denies that he engaged in misconduct. Do you think his attorney had a hard time writing that sentence? Because, like, if I was his attorney, I would be like, ha ha ha, Proctor denies that he engaged in misconduct. I would be like, this is great. This sucks. I mean, he does believe he did not engage in misconduct, so it's not a lie. He believes that he did not engage in misconduct, so it is not a lie. That he can believe whatever he wants. He can believe that the freaking sky is pink. Anytime I'm like, I use the sky as a reference, I'm like, and I think of a color, like he could believe the sky is blue, but like the sky is blue. He can believe the sky is pink. Like sometimes the sky is pink, like when the sun is setting. So like the sky could be pink. I don't know. The sky is purple. Sometimes the sky is purple when the sun is setting. Like the sky could be many colors. I have to come up with a better analogy for that. So weird. Okay. Sorry, random tangents by Stephanie. Moving on. Other than Proctor denies that he engaged in misconduct. Admitted that Proctor grew up and resides in Canton. Admitted that Proctor's sister was a friend of Julie Albert's. Admitted that Proctor and Julie Albert had each other's personal cell phone numbers. Denied that Proctor is a good friend of the. How can you write in a sentence? Admitted that Proctor's sister is a friend of Julie Albert. Admitted that Proctor and Julie Albert had each other's personal cell phone numbers. Denied that Proctor is a good friend of the Alberts. Denied that Proctor intentionally suppressed the existence of any relationships. Denied that Proctor protected any of the House defendants. And denied that the plaintiff's right to a fair investigation and trial were undermined. That's a lot of words. If you have, listen, if you have the personal cell phone number of somebody, like Julie Albert, okay? Like, let's just play this out real quick. If you have if Proctor has Julie Albert's cell phone number, explain to me a scenario in which that would indicate that they are anything other than good friends. Yes, he is being sued. I made a video about that. He's being sued by like 4 different people. He has a bunch of suits. Like truthfully, I can't. We're talking about the Karen Reed's civil lawsuit. Um, Welcome in. I can't imagine a scenario in which he would have Julie Albert's cell phone number and then assert how that they were not good friends. That's a weird like 2 sentences to be next to each other in a answer. I don't know. I don't know how you feel about that, but that's how I feel about it. Okay, next section. Proctor, Buchanan, Tully engage in a corrupt and biased investigation by not investigating inside the House and interviewing House defendants as friends rather than suspects. Proctor denies that the interviews of the House defendant were outside of normal protocol. Proctor admits that the interviews of the House defendants were not tape recorded. Mm. Proctor denies he engaged in an unlawful investigation, that he was biased and or corrupt. Which is like kind of a little funny to me, like funny haha, because like that was why he was suspended and terminated from MPD. Like they found that he was those things. So that's a matter of public record at this point. So whatever. Whatever. Release him as be it. No, I agree with you. I think truthfully, and this is why a bunch of his cases are now being very problematic. I think he believed what he was doing was correct. And that's not, you're right, that's not okay. I think that it was a culture for MPD. I think it was and for Canton PD and it had gone on for years and years and years. This was something that was taught to them. This was something that was handed down from them from previous officers. I think that this was just something that they had engaged in for years and years and years and years. And it isn't just with Proctor, it isn't just Tully, it isn't just Buchanan. It's a cultural, but you're right, cultural thing. Um, and I think that it took a case like this for it to be brought to the surface. It happened in the county that I work in too. It just it takes one case where someone pays attention or where someone messes up and it blows everything out into the open, and that was this case. Okay. Yeah, I mean, evidence tampering is a whole new level. Is super super out there. Yeah, I mean, just what it is. It. Okay. Proctor admits that he interviewed the McCabe's and Brian Albert on January 29th at the McCabe's home in Canton. Proctor admits that he interviewed Nicole Albert, Brian Higgins, Chris Albert, and Julie Albert. Julie Albert, whose cell phone number that he had. Denied that Proctor failed to conduct a meaningful investigation, admitted that Proctor interviewed Higgins and that Higgins presented some text between himself and the plaintiff. Further admitted that Higgins reported that he and Reed had kissed. Proctor admits that he did not do further interviews with Higgins, denied that Proctor hid any video. This was where I was confused. What do you guys remember in the trial? Was there something that Proctor that there was a that Proctor had hid a video from Higgins? No, I would agree with that, but in the context of like this group of people, I feel like in what other circumstance, like why else would he have Julie Albert's like number, right? Like Julie Albert and Brian Albert. Like I feel like in this scenario, I feel like it's weird to me that he would have her number in general. Other than if he was like friendly with her. Like that's not like a random number that he would just have. Like just because. In my opinion. Oh, so we're talking about the one outside the where he's like moving the cars? That one? Or the one where he was inside walking in that corridor? I'm intrigued. I'm intrigued. Both. Okay. Okay, cool. Thank you. Thank you. I was curious about that because when I was reading this earlier, and I was like, I can't remember. It's been a minute. It's been a minute. These are the ones I really enjoyed earlier because these were the ones that I found very interesting. Admitted that Proctor spoke to his sister Courtney. Denied that Proctor failed to probe any stories and denied that he coordinated stories through his sister. Admitted that Courtney told Proctor that Julie Albert wanted to give Proctor a thank you gift, which was never offered nor accepted. Admitted that Proctor told Courtney to tell Julie Albert to give Proctor's wife the gift, which was never offered or accepted. Denied that Proctor treated the Alberts like family friends. Admitted that Proctor shared some details with Courtney. I found this section about Courtney to be quite interesting because wasn't Courtney the one with the couch, like talking to Julie Albert about the couch? Wasn't that whole thing? Or is that some? Or is that Gemma? That was Gemma Cabe. But I feel like Courtney was involved in that. It was Gemma Cabe. Okay. I don't trust Courtney either. I don't trust Courtney either. I don't trust Courtney either. I don't know. We could talk about the Charlie Kirk stuff after we're done going through this because Tyler Robinson had a hearing today, and I want to get your guys' opinion on some of the stuff that they talked about in the hearing today. Because I found it to be very interesting, and MJ and I actually disagree on it. So you're gonna have to solve the conflict of interest. Okay, moving on. This is, I just want to like point out this line as well. To the extent that they can be construed to be read against Proctor, they are denied. Rather than investigate their friends and brethren, Proctor, Buchanan, Tully, and MSP target Karen Reed. Deny that there was a substantial evidence exonerating plaintiff and implicating others. Admitted that Miss Reed's cell phone and her SUV were seized on January 29th. Admitted that Proctor texted his high school friends on the evening of January 29th, the day he began his investigation. Denied that the MSP had not visited the crime scene. Denied that only cursory interviews of the McCabe's and Brian Albert had taken place. Admitted that Proctor told his friends that O'Keefe had been hit by a car. Denied that from the outset Proctor was determined to pin it on the girl. That is wild to me because that's what he texted his friends. He texted his friends that. So I don't know how you can deny that when that's in writing. Like it's literally in writing. But whatever. Proctor is Proctor, and we know that he lies. So um denied that Proctor was biased and had conflicted relationships with the investigation, admitted that Proctor knows the Alberts, denied that Proctor searched for nudes. I'm sorry. Uh, are we in the Twilight Zone? Are we in the Twilight Zone? I don't know, Robert. I'm gonna read that again. Denied that Proctor searched for nudes. I don't know if he met the discovery. Bro, you admitted that in a text message. I That's a special sort of something, I'll tell you that much. Denied that Proctor manufactured a case against Miss Reed. Denied that Proctor generated false incriminating evidence against Miss Reed. Admitted that Proctor took no photographs of the inside or garage of 34 Fairview. Admitted that Miss Reed's SUV was towed to the CPD Sallyport. Admitted that Massachusetts was in the middle of a nor'easter. How many times do you think the word nor'easter has made its way into the answer? Because I don't think it's a lot of times. Denied this one. This one it was a good paragraph too. Denied that Miss Reed's Lexus taillight had a minor crack and that the taillight was intact before it arrived at the garage. Denied that the crack occurred when Miss Reed backed into Mr. O'Keefe's car at 5 a.m. that morning as she was leaving to search for him. As to the video referenced in this paragraph, it speaks for itself. Admitted that Proctor and Buchanan followed the vehicle from Dayton to CPD and arrived just moments after the truck with the Lexus. Denied that at some point after the vehicle arrived at the Sally Point, the right rear taillight was almost entirely destroyed. Admitted that one camera was inverted. Admitted that Proctor applied for search warrants to the Stoughton District Court and Norfolk Superior Court for searches of Google electronic records, Ring videos, Miss Reed's phone, Miss Reed's vehicle, and cell tower records. Denied that Proctor's assertion that he seized the Lexus was intentionally false and done to hide any facts. Admitted that Proctor retrieved Mr. O'Keefe's clothes from the floor of the hospital where O'Keefe was pronounced dead. The allegations in this paragraph refer to a document, and said document speaks for itself. Denied that Proctor and Buchanan placed pieces of the SUV taillight on the clothes. As to the remaining allegations, Proctor is without knowledge. Denied that Proctor planted pieces of glass on the bumper of Miss Reed's SUV. Funny, because those pieces of the glass are nowhere else. Further denied, and they made it in that nor'easter from all the way from Karen's house. But hey, what do I know? Further denied that Proctor planted any evidence to make it look like the glass shards originated from a cocktail glass that Mr. O'Keefe was holding when he exited the Waterfall Bar. Denied that the only way for the glass to have ended up on the SUV bumper is that Proctor planted it in an attempt to connect the vehicle to the death of Mr. O'Keefe. Admitted that Proctor interviewed Brian Logren, a town of Canton snowplow operator. Proctor is without knowledge or information. Okay. Denied that Proctor never made any effort to track down Mr. Loughlin. As to the remaining allegations, denied that Proctor secretly made efforts to protect any Albert family members during the investigation. That's bullshit, and we know that. Admitted that Proctor used his personal cell phone to speak with Kevin Albert. Admitted that Proctor and Kevin Albert traveled in Proctor's cruiser to Cape Cod. Admitted that Kevin Albert left his badge in Proctor's cruiser. The indictment, trials, and aftermath. I feel like these are book chapters, right? Like when Karen finally releases her book, like these are the chapters. Admitted that plaintiff was arrested pursuant to a criminal complaint. Admitted that plaintiff was later rearrested. Admitted that plaintiff was tried twice by the Commonwealth and the first trial ended in a hung jury. MSP investigates and punishes Proctor, Buchanan, and Tully for their misconduct during the investigation. All in all I'm reading here. Oh, guys, thank you for the heart maze. I have missed descending of them, so thank you very much. I appreciate it. All like, it's not giving us a lot, but it is giving us a lot, and I know that does not make much sense, but it does in my brain, and I'm going to explain why. Hold on. I have to appeal my restriction. Give me a moment. Okay. It does not contain original content. You're very welcome. Okay. Da, 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 da. Admitted that Proctor testified at the state grand jury. Admitted that Proctor was relieved from duty. Admitted that Proctor was transferred out of the detective unit of the Norfolk County DA's office. Admitted that Proctor was terminated from the Massachusetts State Police Department. Malicious prosecution under the Fourth Amendment against Proctor, Buchanan, and Tully. Admitted that plaintiff was indicted by a grand jury. Denied that she was arrested without probable cause. Denied that Proctor violated Miss Reed's Fourth Amendment rights against unreasonable search and seizures. And he asked that this count be dismissed with prejudice. Now, again, to remind you guys, with prejudice means that they can't refile. Without prejudice means that they can refile. I know that that's silly, but that's just how it is. Supervisor liability against Buchanan and Tully in their individual capacities. He repeats and incorporates all of his previous responses. Conspiracy to derive Miss Reed of her Fourth Amendment rights against Proctor, Buchanan, Tully, Alberts, McCabe's, and Higgins. Reincorporates all of his previous. I could argue RICO. Yes, I would argue criminally RICO. Absolutely. Denied that Proctor interviewed the McCabes and Brian Albert in a cursory manner. You did, bro. Admitted that Proctor interviewed Higgins once at his attorney's home. That's what kills me. Is if someone like, oh my god, thank you for the gifts, guys. How did you only interview Higgy Poo one time? And he did all this fucking shady shit. And then they asked the court to dismiss this claim and provide attorney's fees, costs, and other relief the court seems proper. Massachusetts Civil Rights Act, Proctor, blah, 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 incorporates, asked to dismiss, common law malicious prosecution, incorporates, asked to dismiss, intentional infliction of emotional distress, incorporates, asked to dismiss. No, it wasn't her finest moment, but like, it doesn't mean she killed him. Civil conspiracy, incorporates, asked to dismiss. This is where we yeah, it wasn't a proper interview. And like the thing is I understand courtesy, right? Being given to other law enforcement officers, right? They're going to be giving them courtesy regardless of whether or not we think that's appropriate or not, right? Because these are other law enforcement officers interviewing other law enforcement officers. And certainly Brian Higgins has the right to have an attorney present while he's being interviewed by another law enforcement officer. But Higgins came prepared, right? Not, he didn't turn over his cell phone, but he printed out the text messages. Whether or not that is all the text messages that existed, we don't know, because we know that Higgins destroys his phone, right? So we don't know what else was on there. We're not going to know what else was on there. There's no. So he had time to sort of set up how he wanted to present what he was going to do. But, why would you not have taken his cell phone at that point in time? Oh, yay, the appeal was approved. Yay! So, I don't know. It's just, Proctor's a piece of work. Here we go with the qualified immunity. Defense number 3. Proctor is entitled to, and plaintiff's claims are barred by the doctrine of qualified immunity. Defense number 4. Proctor is entitled to, and plaintiff's claims are barred by the doctrine of common law immunity. Defense number 5. I agree, Farm. At all times, Proctor acted in good faith, without malice, and without corruption. Defense number 6, Proctor's alleged actions and omissions were not the proximate, factual, legal, or but-for cause of plaintiff's alleged injuries. Defense number 7, plaintiff's alleged injuries were caused by persons or entities for whom Proctor is not responsible. Defense number 8, plaintiff comes to the court with unclean hands. We talked about unclean hands this morning. Defense number 9, at all times Proctor acted reasonably and in good faith. Defense number 10, plaintiff has failed to mitigate her damages. Defense number 11, plaintiff's complaint is frivolous and not brought in good faith, and Proctor is entitled to cost, attorney's fees, and expenses. Defense number 12, at no time was Proctor's conduct extreme, outrageous, or beyond the bounds of decency. That one is pretty funny because you called her a C word in text messages and talked about her health issues in an extremely foul and disgusting manner to your friends, and then told them that you were looking for her nudes. I don't know what is more extreme, outrageous, or beyond the bounds of decency. And then you were fired for it. And then you were decertified for it. So I'm just a tad confused on defense number 12. Defense number 9. A couple of these. I'm a little confused on a couple of these. Yes, obviously, as his attorney, you put all of these in, right? Because one of them might stick, right? One of them might stick. Certainly, it's an approach. Absolutely, you throw it in because one of these might stick. That's why you do it. It is what it is. Plaintiff's claim is barred by the statute of limitations. I'm not sure what the statute of limitations is here, but I can go check that out so we would know. But I doubt that it's beyond the statute of limitations because her defense team would not have screwed that up. Defense number 14, Proctor's actions and conduct were protected by legal process, and therefore plaintiff cannot recover. Defense number 15, at all times, Proctor acted in good faith in accordance with the Constitution and laws of the United States and the Commonwealth of Massachusetts. I don't know where in the Constitution it allows somebody, it allows a police officer who is investigating a criminal case to search for nudes of an alleged suspect. If someone can show me that in the Constitution, I would really appreciate it. Of Massachusetts or the United States. Maybe I missed it. What amendment is that in there? I don't know. Bill of Rights. What are we talking about? Uh, Lauren, I'm gonna find out as soon as we get to the bottom of this because I forget the guy's name. Defense number 15, at all time, oh, we already did that. Defense number 16, if the plaintiff was deprived of any rights, which Proctor denies, the plaintiff had adequate post-deprivation remedies and therefore cannot recover. Number 17, oh, we're going to keep going. Proctor was at all times acting in the furtherance of his official duties and relying on a facially valid court order and therefore is entitled to quasi-judicial immunity. At the very beginning, you may have been working in furtherance of your official duties and then you stopped almost immediately. Defense number 18. Proctor submits that because Miss Reed was indicted by a grand jury, he's entitled to presumption of probable cause. I would agree with that. That one I agree with it. That one I can agree with. Defense number 19, the plaintiff was not deprived of any rights protected under any federal or state constitutional or statutory provisions, and therefore the plaintiff cannot recover. Number 20, Proctor did not initiate criminal proceedings against the plaintiff, and therefore the plaintiff cannot recover. Number 21, Proctor did not withhold or conceal. Oh, this is new. Okay, this is interesting. This is a fun one. You ready for this one, guys? Proctor did not withhold or conceal exculpatory evidence from the prosecution. Alternatively, even if such evidence was withheld or concealed, it was not material to the issues presented in plaintiff's criminal cases, and therefore the plaintiff cannot recover. Uh, Someone needs to read the definition of Brady again. That one's a fun one. What about the videos, dude? You certainly didn't turn over your text messages about the case to your friends, right? We had to get those from the feds. So I would say those are exculpatory. Correct me if I'm wrong, but I would argue those are very exculpatory. Those go to the credibility and reliability of the officer, and he didn't turn them over. We had to wait for the feds to get those. So I'm confused. Okay. Um, Defense number 22. The plaintiff fails to allege a conspiracy with adequate specificity and therefore cannot recover. Proctor is immune from suit and liability under the litigation privilege. Defense number 24. The plaintiff fails to plausibly allege facts supported individual capacity claims against Proctor and therefore plaintiff's claim should be dismissed. Defense number 25. Proctor hereby expressly reserves the right to supplement this answer to include additional relevant affirmative defenses as additional facts become available. Proctor demands a jury trial on all of these claims, so triable. Respectfully submitted. Michael Proctor by his attorneys, Pierce, Davis, and Peritano, LLP. Matthew J. Hamel. Served today. Well, that was an interesting read, ladies and gentlemen. Now, obviously, he's not going to admit anything in this damn thing, right? Because why would he? But in general, what did we learn? What did we learn? Um, I can't wait to read the rest of these guys' documents. That's for damn sure. It's interesting to me because Proctor really doesn't have anything left to lose. Truly, he has nothing left to lose. He's lost his job. He's been decertified in Massachusetts. I think his wife still moved out, if I remember correctly. I'm not 100% sure if she's still out of the house, but I do believe that she did move out of the house. So what is he like what it, I don't know, if I were him, I mean, not that there's much left to gain if he was to like be like, "Hey, I'll tell you what really happened." I don't know. What do you guys think about that? Yeah, we learned that he's still an asshole. That, yes. Right? Like, I think it's, I mean, his pride must be, I don't know, his pride must be something else. And I mean, we know his ego is completely out there because he still to this day believes he did nothing wrong. Interesting, Farm. The bit about the Julie Albert gift was for when it's over. It's not over yet, so no gift yet. I wonder what the gift will be. I would settle for nothing less than Cartier. Nothing less than Cartier. Just to be clear. I don't know. It baffles me that we are sitting here and obviously he's not going to admit anything in an answer, right? We're not going to get any sort of dirt in an answer. But it's interesting to sort of see how his attorneys handle things, how they respond to things. It's interesting. Because this is really the first time we're hearing from his attorneys, right? We're seeing how they litigate, we're seeing how they put, you know, things in writing, we're seeing how they are plan on arguing certain things. I find it to be quite interesting. I want to see the McCabe's. I want to see the McCabe's. That's where it's going to get. Because someone has to, we don't know officially yet, Lauren. This was filed in the U.S. District Court. So this is in federal court. Like this was filed in federal court. So as of right now, these filings are all in federal. Right, U.S. District Court, District of Massachusetts. That's going to be, yeah, that's going to be federal. I don't know. I don't know. If I was joined into this lawsuit and I knew something, mm-mm, done. I'm not losing my house, my home, my family, whatever money I have saved to defend. Mm-mm. I would literally be like, for full immunity from prosecution, get a DA in here. I want full immunity from prosecution. I will sing like a bird at this point. Someone has to. Hi, Christy. I don't know. I feel like something big is coming. I do think that The second trial sidebars are coming soon. And those I cannot wait for. Those I am so pumped. I cannot. Those I cannot wait for. That's going to be absolutely brilliant. Because she 100% got worse the second trial around. She was bad the first trial, right? Went through like 6 or 7 days of that. But second trial she was 100% worse. 100% worse. Oh, it was terrible. It was terrible. The second trial was terrible. Never in my life. All right, well maybe not never in my life, but I've seen some shit, but that was rough. And there was a sidebar every 30 seconds. So we're gonna see some stuff that it's not gonna make us happy. Not gonna make us happy. But with that, that is gonna be it for tonight, guys. So I'm going to log off. I just wanted to go through this one with you. And I will see you all at some other point this weekend, maybe tomorrow. Go over some other stuff. But I wanted to make sure we went through this and got this done. So I hope everyone enjoyed it, and I will upload this to YouTube now. So if you didn't catch the whole thing, and Naomi, I'm putting it up on YouTube. I'm downloading it now. So we'll talk about that tomorrow. We'll go over that tomorrow, Maria. So check out the YouTube if you want to see the whole thing, and I will see you guys all tomorrow. Okay? All right. Have a good night, everyone. Bye.